I'm James Swartz, managing attorney at Swartz & Swartz. So many clients assume that when a police officer writes a ticket at the scene of an accident, that's determinative of negligence. But the truth is, there's lots of other evidence that comes into play. There's physical evidence. There's also witness statements. There's also ordinances and laws that need to be looked at. So negligence and the determination of negligence really takes into account many different factors. In Massachusetts, there's what's known as a presumption of negligence. So in order to understand that concept, it's important to understand first what negligence means. Negligence is essentially the breach of a duty by somebody or carelessness that leads to an accident and injuries. The presumption of negligence means essentially that under the law, the wrongdoer is presumed to have committed an act of negligence. In Massachusetts, however, the presumption of negligence may be rebutted or opposed by competing evidence. So if you're involved in an accident and you're shown to have violated certain driving ordinances, there may be a presumption of negligence. However, you're entitled to present evidence to rebut or oppose that initial presumption and show that, in fact, the other driver is responsible for the accident. So the two most important concepts with respect to the presumption of negligence include one, that it has to be connected in some way to the happening of the injuries. And two, it's rebuttable. You can present evidence to show that, in fact, someone else was responsible for causing the accident. Now, if you received the ticket at the scene of the accident, the ticket and the reason for issuing that ticket still has to be related to what happened. So, for example, let's say you're cited at the scene for having a lapsed registration. While that may be relevant to what happened, it's not the reason in most instances why the accident happened in the first place. So the other driver, for example, may have run through a red light and struck you at an intersection. The fact that your registration lapsed certainly has nothing to do with that driver's actions. Another reason why you might be cited at the scene of the accident could be failure to wear a seatbelt. So in a similar way to the prior example, while the failure to wear a seatbelt may enhance injuries in an accident, it cannot be used to show how or why the accident happened in the first place. The question comes up many times: when can an insurance company deny a claim? The simple answer is insurance companies will deny claims in most instances, regardless of the evidence presented, whether it's the issuance of a ticket or other acts of negligence that occurred. So it's important to consult with the right attorney in order to sort through those issues and represent your interests with respect to the insurance company involvement. Finally, what happens if the other driver admits fault? Is the case over at that point? The short answer is, again, that's evidence that can be used in the case, especially if it's recorded evidence. However, there are many other factors that have to be looked at by you and your attorney in order to determine liability and to pursue a claim. So if you have questions about your at-fault accident, contact Swartz & Swartz.